My name is Jennifer Kupar, and I and Dean Kelly have kind of pulled all these great speakers together for your enjoyment this morning. And welcome, this is actually the school's first new lawyer training. Many of you are graduates of the law school, so it's great to have you back in the building. It probably feels like another life, I'm guessing. And congratulations to many of you just passed the bar some a year or so ago, so congratulations to all of you. So law school and the bar exam might be behind you, but continuing education is not. For the rest of your career, you will be going to continuing legal education hours. And so the school wanted to help you out with these 3 hours of the required new lawyer training, this period that you're required to do. And actually, it was one of our recent grads who suggested that we do it, and we're very grateful to her for recommending that we do this. Most of our presenters are connected to the school in some way. They're either professors. You've probably had some of them over your time here, so we really thank all of them for coming, and they're all volunteering their time for us today, so we thank them so much for. Your first hour today is on professionalism. Our two presenters are Professor Avi Cover and Andrew Pellis. Have come up with a really creative title, and I cannot wait to see how they tie it back into professionalism. You can gag a maggot off a meat wagon, and other things not to say to opposing counsel. So curious to see how that applies and how this is relevant to their topic. And when I walked in, I saw that. So that'll be interesting. Professor Cover is an assistant professor of law here at the school. He teaches in the Civil Litigation Clinic in the Milton A. Kramer Law Clinic Center. He's associate director of the Law School's Institute for Global Security Law and Policy. Professor Cover supervises students in the representation of clients in civil lawsuits, primarily in the areas of consumer protection, home repair, predatory lending, tort defense, and housing. He and his clinic students were in the news this fall, filing a federal class action lawsuit against the city of Akron for illegally seizing personal property from the homeless without procedural due process. That's been an interesting story to follow. Professor Pellis is assistant professor of law here at the law school as well, and he also teaches in the Civil Litigation Clinic. In 2011, Professor Pellis supervised 2 students who won a $1.1 million jury verdict from one of the clinic's clients. In 2014, he supervised a team of students who successfully appealed a case to the Ohio Court. That oral argument is scheduled for January, and this is the first time that one of our cases from the clinic has made it all the way to the state's highest court. The issue before the Supreme Court involves the right to collect attorney's fees, specifically whether a judge can award fees to lawyers who serve pro bono when the opposition fails to meet its discovery deadline, or obligations. So that is also an interesting case to be watching out for. So thank you so much, and we'll turn it over to you.
All right, terrific. Well, good morning. For those of you who don't know us, I'm Avi.
I'm Andrew.
And yes, we're going to be talking about how to deal with attorneys who sometimes say such things to you as you could gag a maggot off a meat wagon. Who here has ever dealt with adversaries who have discomforted you in some way, offended you perhaps?
Gagged you even.
All right, not so many yet. Okay, all right. Well,
That's the beauty of being early in your career, is that you have all of that to look forward to.
Right. So we want to go over just briefly. First of all, there are some materials right at the front. I don't know, has everyone been able to get them? We're supplementing the materials you got outside. Three documents here. All right.
One of which is an agenda. So one of the 3 documents that you have that's not in your materials is a little bit of an agenda for the morning. We have 3 broad topics that we're going to cover. The first 2 of which talk about how to deal with difficult opposing counsel, or even not difficult opposing counsel, and how you yourselves can perhaps develop some practice habits that will prevent you from being characterized or thought of as difficult. And then the third is another issue that we want to talk with you about the appropriate new legal credentials.
All right, so the first area that we want to talk about in our very short hour is dealing with opposing counsel at the outset of litigation, right? And one of the things that will often come up, either as you just file, or you receive a complaint, or you receive notice of a claim, is suggestion that your claim is frivolous, or the claim that you see looks clearly to be frivolous to you. So first off, what are we talking about when we say frivolous? What is a frivolous claim?
No merit.
A claim with no merit. And how do you know it is with no merit?
I don't know. I'm a transactional guy.
No basis in law or fact, right? That language actually comes to track very closely when people talk about frivolous claims, right? We often talk about Rule 11, right? People bring up Rule 11 sanctions, and they often are, one of the bases might be that the claim has no basis in law or fact, right? Similarly, Rule 3.1, which is in your materials from the Rules of Professional Conduct, right, also defines a frivolous claim along those levels, right? There's no basis of law or fact supporting that claim, right? That's what a frivolous claim might be, right? So just first, real quick, but it's not always, right? Obviously, it's an adversarial system. What you perceive, perhaps, to not have a basis of law and fact, the other side may see very differently. And in fact, the commentary to the Rules of Professional Conduct, right, actually even to Rule 3.1 specifically suggests, even if you don't believe you could win, what? Is your claim frivolous?
Which gets to your point. If the claim has no merit, does that automatically mean it's frivolous?
No, you could believe that the law should be changed.
Right. Okay. So as Mac has said back there, right, is that you could believe that the law could in fact be changed, right? As long as you have a good faith belief, even if you don't believe you're going to win, right? On it, you like, no, I know, 1,000,000 to 1 odds we're going to win, but you have a good faith belief that you could still win. That claim might not be viewed as frivolous. Well, some of you may have been paying attention to the news. Your Christmas plans may now change, right? The interview will not be showing, all right? For those who aren't aware, hackers got into the Sony motion picture email system, their computer system. They hacked videos. I think now you probably could watch the interview online somewhere. And you may now know the salary pay scales for Jennifer Lawrence and every other movie star. And the racist
Seth
statements.
Rogen got more for the interview than James Franco, I found out.
There you go, right? So everything is now, we know all sorts of things that Sony did not want known. And so Sony hires who? No, not Skadden, right? They hire a lawyer, right? And they hire David Boyes' firm, right? So David Boyes, right? Same-sex marriage will be the law everywhere, thanks to David Boyes, right? Al Gore was almost president, thanks to David Boyes, all right? Super uber lawyer. And he writes a letter, which is in your packet over there, to every media entity on the planet, it would seem. And what does that letter say? What do you imagine Mr. Boyes, hired by Sony, is telling people? Telling the New York Times, telling Fox News, telling Entertainment Weekly. Without even looking at the letter, what do you think David Boyes is going to do? What's he going to tell him to do?
If you get a hold of any of that crap, you better destroy it or I'm going to sue you.
There you go, right? Sort of a cease and desist letter of sorts, right? Stop doing what you're doing, right? Destroy the material. And at the very bottom of page 2, or the second to last paragraph, right? You do not comply with this request, and the stolen information is used or disseminated by you in any manner. SPE, Sony Pictures Entertainment, will have no choice but to hold you responsible for any damage or loss arising from such use or dissemination by you.
They won't even have a choice. Sony is going to have to do it. It's like there's a force of nature that will compel Sony to hold these people responsible. Choice is gone from the equation.
All right. You are the Cleveland.com's lawyer, right? It's your new assignment. You've gotten this very threatening letter. What do you think? And I need to know in 10 seconds, the partner says to you. Right? What do you think? Yes.
If it's already been made public that it's out there, then there's no harm in publishing it.
Okay, so maybe, right, so first blush, right, kind of quick fact legal assessment, right? Maybe there's no harm, it's already out in the public domain, fair use, whatever you want to throw at it, right? What's the harm? Okay, so maybe that's an initial thought. Right? What else? Other thoughts?
What's missing from the letter? You don't even have to read it carefully to just glance through it and sort of see what you don't see.
Any citations to law that would explain why it's illegal to disseminate it?
Yeah, right? So there's no basis, right, earlier, someone said, right, no basis in law or fact, right? Right, what is the validity of this claim? Right? We don't know the law here, right? Mr. Boyce has not cited any law. Now, I doubt it's because Mr. Boyce is not familiar with some of the law on point, right? There might be a number of reasons, both tactical, but also perhaps substantive, right, as to why the law is not cited here. But that's certainly something you'd want to know, right, before responding. Right? What are arguments that would require Cleveland.com to destroy all of the hacked information?
So based on what you do see from this letter, is this threat, this idea that they will have no choice but to take legal action, is it, or hold them responsible, is it frivolous? Is Sony's sort of veiled threat to sue frivolous? Any reactions? By a show of hands, who thinks it is? Who thinks it's not? Who has no idea? Why do you have no idea?
I haven't done any research on it, I haven't read
Okay,
about this.
gold star, right? How can we know? And that's a common thing that we do, that we as lawyers often do. We react to things that our adversaries say and do with our guts, and we sometimes put labels on them that it is or is not frivolous. But the point really here is we can't know that. We can't respond to it with any assessment of whether or not it is frivolous unless we've done the homework we can do, which Mr. Boyce has failed to do for us here by failing to point us to. I mean, that leaves you with the suspicion that it might be frivolous, but you certainly can't conclude one way or the other without doing a little bit of homework. Right?
So let's say you do a little homework, and you decide, based on what Mark said a little bit earlier, right, it's in the public domain, right, this is not, by the way, a legal assessment right now of all these claims here, right? Let's say you draw the conclusion, after your very fine legal research, that Mr. Boyce and Sony Pictures Entertainment do not have a legitimate claim. Right, you decide it's in the public domain, this is First Amendment protected information, we got it, we didn't steal it, we didn't have any hand in stealing it. And so that's your assessment. What now are you going to do? What are you going to, you've received a letter. Common courtesy is usually to respond to that letter, right? Common, perhaps good practice. What would you write? What would you convey to Mr. Boyce?
I think you would tell him that his letter could gag a maggot off a meat truck because it's so frivolous. Is that the right approach? What's your objective? What's the objective in responding to Mr. Boyce? What's your goal?
Assert that his letter is frivolous and respect their opinion based on your research, and then you're going to cite whatever you found that why they're wrong.
But what's your ultimate goal? Why would you do that?
Sit down and shut up so that you can post whatever you want.
So that you're ultimately you want your client to be able to continue to do what your client is doing. That's one goal. What's another potential goal?
Avoid a lawsuit.
That's another. Is there another potential goal? Would there be a consequence to Mr. Boyce or his client or his firm if in fact this were a frivolous claim and he chose to pursue it? So what's another potential goal of sending a letter telling him so? If you send a letter telling him all the reasons that you think his claim is frivolous, and then he goes forward anyway and files it, and you want to pursue some sort of relief with the court that puts him at risk for filing a frivolous claim, it'd be helpful to be able to tell the court, look, this isn't new information. I told him it was a frivolous claim. I already gave him my thinking about it. In fact, Rule 11 has what they call a safe harbor provision that requires you to tell, at least the federal rule, requires you to give the opposing counsel an opportunity to withdraw what you characterize as a frivolous claim by essentially serving your Rule 11 motion before you file it and then waiting the required period of time. So that's a potential third goal, right? Is that goal in your client's interest? Who thinks it is? Who thinks it's not? Who doesn't know? Why don't you know? Because you don't have a client that you've talked to about it, right? I mean, that's the bottom line. Ultimately, your client's interests are that's something you cannot articulate or determine without sitting down with your client and explaining the options. But your principal goal here is the one that I think you mentioned initially, which is to give your client the legal protection to continue to use the material, right? So what do people think about this notion of exchanging correspondence before filing a lawsuit? What's another alternative to sending back the letter to David Boies? The letter that you send back, whether you use the word frivolous or not, okay? It's going to essentially explain to Mr. Boies why you don't agree with his assessment of the risk.
You're doing it to avoid litigation because the last thing you want to do if you're Cleveland.com is get tangled up in litigation with Sony, who has nothing but money to spend on this kind of thing. And your gain is going to be disseminating a free news story.
So your thought, this is exactly where it ought to be, is what's going to be best for your client, right? Is it going to be client to keep your cards close to the vest and not reveal to Mr. Boies all of the reasons that you disagree with his unstated legal theory? Or is it going to be better for your client to get that out in the open early on in an exchange of correspondence that might actually prevent the lawsuit? What's the downside, though, of sending back the letter responding to Mr. Boies' threat and reciting all the law that goes in your favor? What's the downside of that?
You're gonna piss them off, probably.
Okay, well, depending on your language you use, one downside is that you're going to potentially ruffle his feathers. Strategically, though, what's the downside?
And then you allow them to punch holes in all your arguments that you put in your letter to them.
Okay, and there's...
You've given up your law, right? I mean, you've given up that's your motion to dismiss, right? Or your response,
Yeah.
right? So you want to be careful about what you divulge. And so you have those two goals, right? In terms of avoiding litigation, but in so doing, if you're not successful at that, have you then given up some of the strategic value of the case law and your theories of the case?
And so just to illustrate that, okay, one aggressive litigation response would be to send Mr. Boies back a letter saying, I disagree with you. If you think there's harm here, go ahead and file your lawsuit. He files, and then you start off with a 12b6 motion to dismiss, if you remember your civil procedure, with a very aggressive argument that you have not yet revealed, and it becomes the motion to dismiss. And if that doesn't succeed, you come back with some sort of a counterclaim, either based on the frivolous nature of the lawsuit or whatever other counterclaim you can muster that your client might have against Sony, okay? Which you have not revealed ahead of time to Mr. Boies. That's the aggressive approach. Which is better? Come on. It's going to be a long morning for you guys. Bethany, which is better? Why don't you know?
I've never seen something like this in action before, so I'd like to see how things like this have played out, especially with this law firm.
But what else is there about the situation that you don't know, apart from the fact that you've never seen it before? Do you know the history of the relationship between your client and Sony?
No.
Do you know the personality of your client?
I'm sure I would, but no, I don't.
Do you know what your client wants to do?
No.
Okay. These are all considerations that factor. Use your hand up.
Yeah.
Good.
But you don't know what type of client you have. You have that small, teeny, tiny media thing that Sony's not even gonna pay money to even litigate, hire lawyers for, because actually what they're doing, what we're doing, my client is actually gonna promote their movie in a way, because we're still talking about it. Or is it a giant media company that really is threatening their profit? Because I wanna know how big my client is. Are they even gonna waste their money coming after us? Then, I mean, it won't be as aggressive, we'll just let it go.
So what's the bottom line if we have to sort of distill this conversation into a sort of summary conclusion, because we're sort of at the end of this time for this topic? What have we read as far as professionalism is concerned and how you practice law? What's the bottom line message?
You gotta talk over with your client, explain the benefits and risks, depending on how you wanna respond to the situation, and get their input, because ultimately they're the ones you're representing, and so however they wanna go about it is how you should do it.
Okay, so that's one really important bottom line, which is always keep your client's interests at the fore, right? Another one? To react with a knee-jerk or not? Never, right? If you're going to do something, especially something incendiary or something that will potentially reveal your strategy or your thinking or give up something that might be useful to you down the road, always know your goal. Think through your goal. Play chess, not checkers. Understand how the moving pieces on the board might play out. And when you decide how you respond, make sure that your goal is always the thing that you're working toward and not something that you're going to let sort of happen after you have your little letter where you blow off steam. Write the letter. Call it frivolous. Do all the research and threaten sanctions. Just don't send it if that's not actually in keeping with what you conclude your goal is. Pros and cons of...
Oh, we're going right there. Okay. So you're dealing with Mr. Boyd now. Litigation has gone forward. You have not been able to avoid it despite all your valiant efforts. And Mr. Boyd wants a little bit more time before he responds to your discovery requests. What do you do? Yes.
Ask him if he'll return the favor for you.
Okay, right? So sure, right? There's a little quid pro quo, right? A little reciprocity in litigation is always certainly a concern. So you're right? You scratch my back, I'm gonna scratch yours. There is that consideration, all right? So that might be one approach, right? You wanna make sure that it's gonna be good for you as well. What else? What else might be a consideration before you say yes or no? Yeah.
Just consider whether the court will likely grant it if you oppose it regardless.
Okay, right. You have to think about in litigation is potentially before the court's eyes. So certainly if there's a reason or you decide you want to deny it, how would the court react to that?
And 99% of the time, how would the court react to the request? Yeah, unless there's something in the case that really requires fast resolution, like an upcoming preliminary injunction hearing, which there might be in this case. But unless there's some really urgent date coming up, there's almost no judge that's going to deny one extension of time on discovery.
Right. But related to that, right, those considerations, why might you not grant that request? Yeah.
Because it against your client in some way, based on timeline.
Sure, right? So not looking at it abstractly for a moment, how could it affect your client? Could it prejudice your client's interest, right? And then there usually it might be an issue of timing, right? Everything is on an expedited schedule. There's a reason that something needs to be resolved by time X, and so you need that resolution, right? In fact, envision in this case, right? It is in Cleveland.com, right? They're in business of putting up news and what they consider news. So every day that they are under this cloud of doubt as to whether they can post, more information about the disparity between James Franco and Seth Rogen's pay scale, we're all at a loss. And that's against Cleveland.com's mission, right? So maybe then you're going to say no. Right? There might be an argument. No, we can't grant you that. This is going on too long, right? Our sole purpose is to deliver the news.
Let's say there's a preliminary injunction hearing scheduled in this case, but it's not so soon that there's an urgency, so you can live with the 30-day delay. But one of the things you really want to know, one of the things that you've asked for in discovery, you as the Cleveland.com lawyer, have asked Mr. Boyes to articulate in his discovery responses all of the harm that Sony will suffer by virtue of Cleveland.com's publication of these already public materials. That's a really important thing, because that's one of the tests under preliminary injunction standards is the balance of hardship. So you really need to know. So you said, Brian, quid pro quo, I'll give you 30 if you give me 30. What about a quid pro quo? I'll give you 30 if what you give me back at the end of that extra 30 are real meaty responses and not just equivocal answers or objections. Is that a fair thing to ask for? What's your goal? Remember, always keep your goal in mind. What's your goal? You don't want to wait an extra 30 days if you're not going to get the real responses, because if you're going to have to go to court to fight over those responses, you want to do that sooner than later, right? So it's in keeping with your goal to try to basically say, look, I'll give you the extra 30 days, but I don't want to lose my opportunity to go to court if we don't have adequate responses. I need assurance from you, lawyer to lawyer, that what you're going to give me is substantial and not evasive, okay? Now that doesn't guarantee anything, does it? But what happens if you do get the evasive responses at the end of the second 30 days? What do you do at that point?
File your motion to compel and remove that correspondence,
Why?
because they've already agreed to give it to me in that timeline.
Well, there's some element of what they've already agreed to, but also what does it show the court that you did? Yeah, right. And isn't that always what courts want to figure out, is who's the party here who acted reasonably and who's the party who's stalling or who duped the other side, okay? Think about that from both a client goal perspective and a professionalism perspective, and maybe you can marry the two, because it does give your adversary what he or she has requested, and at the same time, it might set you up well for your ultimate goal of getting the meaty responses, or if you don't get them, of getting the court to understand your complete reasonable approach here that the other side took advantage of.
So to sum up then, on this issue, right, I think generally speaking, it is going to be the common civil thing to do to grant and honor those requests, expecting some level of reciprocity, right? That's going to go on. You're going to often, much civil litigation goes on for a very long time, so you want to establish a good relationship, not the least of is to show that courtesy and grant that time, expecting that you'll get it back. And that is a good way to maintain that relationship. That said, always keep, right, your client's objectives in mind, making sure that there isn't going to be any prejudice. What about filing motions? Motion to strike, for example. Why would you ever file a motion to strike?
What is a motion to strike?
Under Rule 12, right, you've got a variety of motions that you can file when you face various pleading. One of them is a 12F motion, a motion to strike, right, to get rid of scandalous, impertinent, or salacious material.
So let's say, for example, that Cleveland.com files an answer in this case, and in the answer, it reveals some of the worst things that the hackers exposed in the Sony correspondence. There's stuff in there about various executives and comments made in emails. I actually, honestly, have not read it in detail, so I can't tell you what it is. But it's embarrassing to Sony. And in response to the complaint, Cleveland.com files an answer that essentially regurgitates all this stuff in the emails. What might Sony want to strike? Scandalous allegations in the answer that have nothing to do with the dispute, right?
Right. Right, so one of those, right, is going to obviously realize then one of Sony's goals, right, your client's goals, right? We don't want this stuff out in the public arena, so we file that motion to get rid of it, right? Why might you not want to file such a motion? Yeah?
Draw attention to it.
Sure. Right, I mean, sometimes the worst thing to do is cry foul, and there's a foul, right? And everyone's now seeing it, right? So yeah, you make it more of a topic, right? More of an issue. Why else might you not want to file a motion to strike?
Rarely ever granted.
Yeah, it's not a frequently used device, right? And obviously it's gonna sometimes be context specific, right? And there may indeed be instances that are gonna rise beyond the pale. But if it's not usually granted, why would you not want to file it then? Sure, it might waste your time. Who else might it annoy?
Judge.
The judge.
Because it doesn't make you look reasonable, right?
Even with all that, why might you still want to file this motion?
Maybe it's so inflammatory that you feel compelled to do so.
Okay, so it might just be right. I mean, it just raises the level of pique. It is so upsetting. You know, notwithstanding the lack of likelihood that it's going to succeed, you still feel you need to do it on principle, right? Standing by your client, zealous representation. Why else, maybe? What could it convey to the other side? Yeah.
I was gonna say maybe the client just wants you to do it.
All right, client just wants to do it. So again, right, making sure though, right, that we're not filing something frivolously, right, taking those considerations. But sure, again, honoring your client's wishes and objectives. Why else might you want to? What message might it send to opposing counsel? Yeah.
Just that you're gonna be aggressive and you're gonna like keep.
Yeah. Right. You're going to be aggressive, right? You're not going to take anything. Now, again, you don't want to do this just for purposes of delay and creating an adversarial system, right? And so you need to be careful about how those objectives are, right? And so that probably doesn't want to be your overriding reason. But as a factor as to why you might be sending a message to the other side that this is going to be rough, right? And we're not going to take these things,
Which is
something
a
to consider.
fantastic segue into the next item on our agenda, which is aggressive discovery. Why do people behave aggressively in discovery? Why do lawyers behave aggressively? I'll give you an example of one of the cases that we had in our clinic a couple of years ago. It was a very simple contractor dispute. Our client did not like the work that a contractor had done on her home. She had written the contractor a check. After she realized that the work was subpar, she canceled the check. And the other side, in aggressive discovery, subpoenaed her bank for 2 years of bank records. And I'll tell you in a minute what the ostensible purpose of that was, but it put us in this position. A subpoena is something that we have no control over. The bank was subpoenaed. We had to move quickly to quash the subpoena so that the bank wouldn't turn over all of these personal financial records of our client. And the court then has to rule on that because the bank is going to do what the subpoena requires unless someone tells the bank it doesn't have to. All right? Is that too aggressive? On the other side? Why did the other side do it? Do you think?
See if this woman has a history of just canceling things when she doesn't do what she wants.
That's exactly the reason they articulated. That's exactly why they said they did it.
You wanted to compel her to pay up.
And what tactic were they using?
Intimidation, making you turn over private information.
Right. I mean, litigation is really distasteful, and people who haven't experienced it when they go up against a lawyer like that. And often, you can extract a settlement out of your adversary by really being aggressive in discovery. It's one of the ways that people really take advantage and often abuse the litigation system, right? So, if you can articulate a theory for why you're entitled to this discovery, then you're at least a little bit ahead of the game as far as any kind of accusation someone might make against you that you've. But how many people think that subpoenaing 2 years of bank records to look for a history of canceling checks to people who do work on your home is reasonable? Raise your hand if you think that's going too far. Raise your hand if you think it's totally reasonable. You have a right to it. Raise your hand if you don't know or you're asleep. Okay. Well, the court didn't quash the subpoena. The court let that subpoena go forward. And guess what? the case settled, okay? So that's an unfortunate example of the court not coming to our defense when we really, I think the majority of those of you who expressed an opinion thought that was going too far.
Sorry.
No.
What might you do in that scenario, though? If you're representing a person who had 2 years of bank records requested, right? What are some other options, some perhaps reasonable accommodations, compromises that you might propose in response? Yeah.
Propose a narrower scope. Give you 6 months.
Okay, yeah, right. So certainly on discovery, there's room for negotiation, right? Saying, well, I think 2 years goes too far, but how about just 6 months? Right? Yeah.
You could even give them a list of people who performed home repairs in the past 2 years, and then they can interview those people. You know, put it back on them. Say, you know, well, the past 2 years there have been no home repairs, so we have there's no ability for a cancel check. Or there has been a plumber that came. Here's his name and phone number. Call him and ask him.
Yeah, but that's only going to give me what you call home repairs, and even then, only if you're honest about who came. Who knows what other cancel checks there are for other kinds of things? I don't want to buy your.
So outside the scope of the litigation, then. You can go back and forth, but I mean, you're at least trying to narrow something.
Yeah, so certainly some sort of response, right, to negotiate over those terms. Yeah. Over here.
If the concern is privacy, you can ask for a stipulated protective order.
Absolutely. So one response off with discovery, right, is to suggest it, is to seek a protective order, right, which can then ensure a level of confidentiality if that is indeed the concern. It can also narrow the scope if indeed you can't reach some level of compromise, right? So under Rule 26C, that might be a very good option to pursue.
And all the things that you do along these lines, along what Diana suggested, the protective order idea, all ultimately, if they fail and you do have to go to court, make you look more. There you go. All right.
Well, on the flip side, right, so you've got on one side, sometimes the attorneys who will seek over-aggressively, right, discovery. What do you do, though, when you're on the other side and you receive nothing, right, or basically nothing, responses that are worthless, right? Why do attorneys do that?
Let's say that you were the contractor's lawyer and you asked for the list of all home repairs and who did them, going back 6 months or 2 years or whatever. And what you get back is, objection, this is not about any other home repairs. This is just about the one repair that your client did inadequately. I'm not going to give you this information.
Yeah.
I mean, I know you have to try and resolve it. The other attorneys are going to court, so call them maybe first and just say this is not responsive, and that you have an obligation to answer these discovery requests. Your answers.
Okay. And the other side says, no, I've given you my objection, right? It's just not information that's discoverable.
Not for 1 second on Mark's point that you have an obligation, because you do, and that is in your materials. You have an obligation under Rule 37, Ohio Rule 37. You have an obligation under the Cuyahoga County local rules. And in federal court, the whole system is completely different because you're not even entitled to go to the motion to compel route until you first have a conference call with the judge. So those materials are all in your packet, but yes, that's really important. You have an obligation to try to resolve things court before you resort to the court, and sometimes you have to actually use language that the rule specifies about what you actually tried to do.
And the key thing, what you'll want to hear, right, and if indeed you are someone, for some reason, wants to limit discovery as much as possible, right, you don't want to give up a lot of information, right, you have to be providing specific objections, right, the general objections cannot be a basis for that, right, but as much as you're going to try and paper this with negotiations and the like. We should move to depositions.
Depositions. All right. This is where the title of the segment this morning comes into play. So, who here has heard of Joe Jamel?
Oh, you have to do in Texas? It's like...
Before we play the video, I will tell you. Well, let's play the video first.
This is not Joe Jamil,
Well,
just to be
he
clear.
is in the, this is.
This is not
this,
it. Right,
you hear
no,
his
no, no.
voice.
Right.
This man sitting next to you before this deposition started.
Yesterday, but he had nothing to do
I didn't
with
ask
what
you
you are
that.
currently
Did you talk-
saying.
did you
I
talk
said
to
it,
him?
though, didn't I?
Did you talk to him, sir? What'd you say?
I said nothing. I said, you have a case of incipient verbal diarrhea.
Oh, sir, we're going to see about that.
Well, good.
Him yesterday.
Yes.
How long?
About 3 hours.
Talk about this case? Tell them the other companies you consulted for?
No. I
You're
did
under oath here.
I did not.
We'll see about it. When you were at Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
Research chemist.
And was that your title during your entire stay at Texas City?
Texas City, yes.
Don't talk over each other.
After you left Texas City,
Wait a minute, let me ask a question here.
yeah.
Do you represent this guy or not?
Who are you?
My name's Tucker, and I represent Ayrshire. I represent the guy or not. I'm getting, if you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Why don't you keep your mouth shut? I'll do what I want.
No, you're not
Hold
going to do
it.
what you want.
Oh, wait.
I'll do what I want.
No, you're
No,
not.
you're not.
Yeah, I am.
That's
I'll make
bullshit.
whatever objections I want to make, and I'll make them as loud as I want to make them. Or you just shut your mouth and we'll keep the record straight.
Don't tell me to shut my mouth, boy. You may be big, but you want to see how bad you are? Come on.
And I wouldn't try that, Ed.
Are you threatening to fight?
Hold on just a second.
I want to know who's saying what. We're going to be outnumbered, Ed.
Hold on just a second.
No, you got a big mouth. No, you do. You need to either represent the man or not. I've tolerated it.
Monsanto, and I'm
But
making
you're
an
not-
objection on the record.
Then you're not entitled to be his lawyer then, okay?
I'm not representing the man.
Well, you're
I'm
trying to
making
be.
an objection on the
And another
record.
thing,
Don't tell
you
me what
don't.
I'm trying to do.
Yeah, I'm going to tell you something else. You don't run this deposition. You
To
understand?
you, Joe.
You watch and see. You watch and see who does, big boy.
I'm telling you, Joe.
Oh, you ain't telling me a goddamn
I'm gonna make
thing.
whatever objections I want.
You can make your objections and keep quiet. See,
No,
but don't
I'm
be
not.
telling another lawyer to shut up.
Don't be.
Damn
No,
job,
that's not
fat
your
boy.
job.
Now get back. Now you got
As I said before, you have an incipient bad
What do you want to do about it, asshole?
Oh, I'd like to knock you on your
Well,
ass.
come
I'm
try
not
it.
gonna do that.
Come over here and try it, you
Wait a minute.
dumb son of a bitch.
Wait just a second.
Come over here. Hold it. Hey, wait a minute. Hold on. Hold it. No way.
Get close.
Why don't-
Hold on just a second.
Associate of taking Mr. Garrett out in the hall to lecture him, I suppose. They're doing this over our objection. We started this deposition, unable to get an answer from this man.
All right, Joe Jamil, ladies and gentlemen. In your materials, you have a copy of a decision from the Delaware Supreme Court. It's a decision in some sort of a corporate dispute. The issue of Joe Jamil's conduct in that case was not before the Delaware Supreme Court. But when the court read the record and saw how Mr. Jamil behaved in a deposition, not even this one, this is a different case. In a deposition in that case, he behaved so badly, including saying to his opposing counsel, you could gag a maggot off a meat truck or a meat wagon, that the Delaware Supreme Court took it upon itself in appendix, which is in your materials, to essentially kick Joe Jamil out of the state of Delaware permanently, and he can't practice law there again unless he comes forward and explains to them why he behaved appropriately, which of course there's no way to do. So, lesson number one, never be obviously, right? Never say that sort of thing to opposing counsel. But what do you do when you are on the other side of a case like that? You saw the other lawyers in this case really didn't behave a whole lot better than he did. What do you do when you are on the other side of aggressive deposition conduct that is crossing the line, maybe not quite that badly, but making it impossible for you to do your job? Let's say you're taking a deposition and the defending lawyer is behaving the way these lawyers do. What do you do? Right?
Move the deposition to the courthouse.
How do you do that?
Tell them you're walking out with your client. This is abusive.
What if it's not your client? What if your client isn't even there? You're taking the deposition. It's their client who is the one supposedly giving the answers, and you can't get answers because of the way the other lawyers are behaving.
Well, create a record, especially if it's not videotaped, is the first step.
Well, let's back up a second. You say especially if it's not videotaped. One important tool that you have, if your client can afford it, is videotape. Because there's nothing, I mean, this is really unusual in that these folks were willing to behave this way with the camera running. There is nothing as behavior controlling as a video camera. It works wonders. In fact, if you don't have a video camera and it's so bad that you call one in, you will see a complete change in of the folks there. But of course, that's not always cost effective. It's expensive. Go on.
If that doesn't work, I guess, in federal court, you could call the discovery or you would leave to try and work things out.
What's the problem with calling? There's often a magistrate who's in charge of discovery. Sometimes it's a judge. In state court, it's almost always a judge, or more likely what we get on the phone is the staff attorney, right? What's the problem with that approach? What's the difficulty with it? How happy will the person answering that phone be to get your call?
Well, yeah, I mean, it's gonna make you look like a whiner, and it's gonna take time, and it might not solve the problem.
Why will it make you look like a whiner?
Because you're like crying to the person.
But this behavior is unacceptable.
Yeah,
Why
I know,
shouldn't?
but you should probably learn to deal with it yourself.
Well, what's the real problem though about getting across on the phone? What happened?
Well, I was just gonna say, you don't want discovery dispute. You want discovery.
Well, that's the ultimate problem, is that you want to get your discovery. But the real problem about making the call in this situation is there's no way that the person answering the phone is going to know or even understand what you've just been through, right? They haven't. You've heard all this. You're upset, you're angry, you're frustrated, and you express that in the phone. But they don't understand why you are. They don't have that background. So there's really no great way to convey over the phone what has happened here. So what's another alternative? You were, Becky?
State on the record what is happening. Like they're talking over you, they're not letting the person answer, so we still have to do the transcript so you can complain about it.
So think really carefully, especially if you don't have a videotape, about what that transcript is going to look like. Do not argue with opposing counsel, especially over each other's words, which is impossible for the court reporter to take it down accurately. Your goal in that situation is the best transcript or video, if you have the means, you can get, so that you can then, if necessary, make an informed decision afterwards with a little thought and a little kind of passage of time, whether the behavior was so bad and the compromising your discovery was so great that you want to present that to the court in a way the court can actually see it if they take the time to read it, right?
Just a couple things to add to that, right? There is a different dynamic if you switch that scenario around, I think, and it's your client, right, who is being subjected to that sort of thing. Right? That has to take precedence. And if the client is being abused in such a fashion, I think you want to be prepared to perhaps stop it right there, perhaps call the court. All the same rules of documentation and such certainly apply, and you want to make sure you have that record. But that's a key concern. Another wrinkle, and it courses through all of this, right, is your obligation as an attorney now to report other lawyers' ethical violations. Right? There are violations of the rules of professional conduct that touch on trustworthiness, honesty, the fitness to be a lawyer. You are obligated to report that to a disciplinary authority. And making that call, I don't think it's actually a very difficult call in the video we saw, that actually you would probably be obligated to report that conduct. But making that call is a serious question that you have to face as a lawyer. That said, threatening to do so for tactical, strategic reasons may also be a violation of ethical conduct. There are different rules committees going through those sorts of issues, right? So that's a very difficult balance that might at first feel like, okay, I'm completely on the side of the angels here. But how you put that into effect, how you remonstrate with the other side, and what you ultimately do are much more difficult calls.
And it's especially more difficult because you can take Joe Jamel as a really good extreme example. But I'm almost willing to promise you, and I certainly hope this is true, that you will never actually encounter lawyers behaving that badly in your actual practice, in your depositions, for example. You're going to come across lawyers who are acting badly and obstreperously, but not so obviously badly that you can be satisfied without any doubt that it's an ethical violation and that you have the obligation to report it. You're going to have situations that are really closer to the line and much more difficult to convey the way you want to the court, which is why making the best video or transcript you can, think about how said in a room actually end up looking on the page. You know, when you're involved in depositions, even without this kind of conduct, make sure you really start to study how things turn out on the page after the dynamic in the room is gone, because that's what you're going to be left with, that's what you're going to be required to present, and ultimately if you make a complaint, whether it's a discovery motion or an ethical complaint, it's all going to turn on the record that you have, which often is not nearly as heated or emotional as the room felt at the time that it happened.
Yeah. There are, as much as it can often be amorphous, there are rules that govern depositions and the conduct of them, right? And we have some of those in your materials. Local rule for Cuyahoga County 13.1 is applicable. I would always bring that with you. Sometimes you need to show that to the opposing side, right? And remind them that there are applicable rules. Rule 13.1 references the do's and don'ts put out by the Ohio Supreme Court, which are also in your materials. Sometimes letting someone know, no, you can't act that way, can go a long way. And I do always bring, not that very rarely have I ever used a number, but I always do bring the judge's phone number or the staff attorney's phone number with me to any deposition.
And one other sort of rule of thumb about dealing with difficult people in depositions, do your best never to engage in conversations with opposing counsel. If you're taking a deposition especially, your job is to have a conversation with the witness. Any conversations that you have with the opposing counsel defending the witness are only going to distract you from your objective of getting testimony. If the opposing counsel says something that requires a response, asks you a question, you don't want to be rude and ignore it, but the minimal response that you can get away with so that you're always focused on the witness. Because the more you let your adversary distract you from that, the more you are going to fall victim to whatever distracting tactics they've decided to employ. All right.
So you're all lawyers now, right? So the great thing about that, right, is you can have a fool for a client, right? You can represent yourself. Who here, either in law school or now already full-fledged lawyers, has seen fit or had the need to show off his or her legal skills in dealing with, owner of another establishment, a landlord, a car dealer? Anyone?
A contractor.
Come on, one of you has, right? That's a name. Care to share?
I had a landlord who was, we'll call him incompetent to be nice, and I just was, just wasn't getting things done, so I had a neighbor that smoked a lot of marijuana, and my landlord knew about it. One of the issues was about the marijuana in my apartment. Basically, the real issue was he wouldn't tow people who were blocking me in. I missed court one morning because I couldn't get to court. And so I just showed him the rule that is now defunct, that if you are a landlord and you know that somebody's smoking marijuana in your apartment, you have to evict them. And then I said, I hope I'm not blocked in anymore. And then he started towing people. So that's...
Did you say that you were a law student when you did that?
I was a law student.
Mm-hmm.
It was a very small building. He didn't even have one building.
Well, let's take a look. You might have heard about this in the news, and you have some materials, but a professor of law has decided to be his own champion, or maybe the champion of the little people. You decide. Meanwhile, you get a Diet Coke commercial. This lecture is sponsored by Diet Coke. Please drink responsibly.
Ordering Chinese food is a bit of a gamble. Hopefully, you get what you order. Hopefully, you don't get all gassy and bloaty. And recently, Harvard Business School professor Ben Edelman ordered $53.35 worth of food from Sichuan Garden Chinese restaurant, only to find he was overcharged by $4 because the prices listed online were out of date and actual price. He was so displeased, he took it upon himself to send an email stating, Massachusetts law, it turns out to be a serious violation to advertise one price and charge a different price. I urge you to cease this practice immediately. If you don't know how to update your website, you could remove the website altogether until you're able to correct the error. The internet kind of blew up. Is he an obnoxious asshole, or is he a champion of the little man?
Obnoxious asshole.
One thing we do know at last is who the paper delivery boy from Better Off Dead grew up to become.
4 weeks. 20.
Okay, what they didn't tell you in this little clip, and that you may have heard, is this guy's not only a professor at Harvard Business School, he's also a Harvard-trained lawyer, and he ultimately threw around his law degree and his law license in the email exchanges, which I think you have in the materials that we gave you today. Abuse of your law license or responsibility to protect the little guy? Why?
Because uncalled for. It wasn't, in my opinion, was not a legal transaction. So, a customer, there's a misunderstanding. I think immediately the owner apologized, tried to rectify the situation, but yet the attorney, it seems that an accomplished attorney, tried to manipulate a situation. His figure all over what $8 more than what the owner was trying to rectify. It's unnecessary. He was a bully. He was a politician. He would lose his job.
Other thoughts? If you do have personal disputes, whether with a Chinese restaurant or a home repair contractor or Best Buy, is it ever appropriate to bring out the lawyer card? You're saying no?
No.
Does anybody think it is? Who says yes? How come?
I don't know why you can't. I mean, that wouldn't be the end of the argument, but I mean, I think it's reasonable to work that out. Not in a threatening way.
How do you do it in a not threatening way?
Just sign it. Yeah.
Other thoughts about it?
That's like a couple of my friends would argue, I'm about to call my lawyer and resolve this. I mean, it's a bully tactic.
Well, let me turn it around a little bit. What if the Chinese restaurant said, screw you, I don't $8, you know, it's just a website, we can charge whatever we want. If you want to know what the price is, before you pick up your food, ask when you call, okay? And you really, really do believe that it isn't about you. It's not about your $8. You really feel in your heart that you're a consumer advocate and you have a responsibility to prevent this from happening to other people. Okay to pull the lawyer card out then?
It's my understanding that if I want to litigate a matter with you, I'm not going to show you my entire cards. I probably won't even tell you that I'm an attorney. I'll let you play the pool for as long as necessary. But then, surprise, yeah, that conversation we had 2 weeks ago, I wrote everything down because I'm not prepped for trial.
So strategically, you're thinking you can maybe get more information or use to your advantage the fact that they may not know that you're a lawyer.
Right, true. And from my standard, I don't want to compare myself to an off-duty police officer who's bullying his badge. Right.
Well, I can tell you from personal experience that people who do not disclose that they're lawyers or are not lawyers have a much, much, much smaller success rate at resolving consumer disputes than people who either hire lawyers or who are lawyers and reveal that fact. There's just no doubt about that at all, okay? So the question you need to ask yourselves, and I think it really boils down to whether or not you're doing it abusively, is if your position is right, and I mean, if you read these emails, the guy was just completely obnoxious, especially at the end when he wanted like $50 in damages for his $8 overcharge. But there is an element of protecting the interests of the public that I don't think if he had done it differently would necessarily have been improper, especially if what he had asked for was changing the website and not asking for his own money back, if that had been his focus. The idea here, again, always, what is your goal, okay? If your goal is personal gain, be careful how you throw around that lawyer card. If your goal is to actually achieve what you really truly believe and can defend as being a just result, not just for you, but for someone else, that might be slightly different. But either way, tone really matters. If you read these emails, you can see how the tone really turns you off to this guy, even if his objectives were honorable.
I think the only other thing to add, right, is you are now part of this profession that is respected by many, but is also maligned, right, and not always viewed with the greatest view, and sometimes for being bullied or manipulated and what have you. And so you do have an added obligation that when you act as a lawyer or pull the lawyer card, right, you are representing, you are an example of all lawyers. And that is something that you are actually bound to under the lawyer's creed of the Ohio Supreme Court and their various professional ideals.
Training materials.
So, anyway, we have come to an end, I believe.
Yeah.
So,
Any questions for us before we go? All right.
Thank you very much. Thank you.